On February 25th, 2019, a Monmouth County, New Jersey grand jury formally charged Paul Canero with 15 criminal counts that included 4 first-degree murder charges and aggravated arson tied to the deaths of his brother Keith Canero, along with Keith's wife Jennifer and their 2 young children, Sophia and Jesse. And this marked the official start of a case that would draw intense public attention. The charges came after a detailed investigation into the violent events of November 2018 in Colts Neck, New Jersey, where authorities discovered the victims had suffered gunshot and stab wounds before their home was deliberately set on fire in an apparent effort to destroy evidence and hide the truth. Investigators later uncovered financial records showing that Paul Canero had been secretly taking money from the business he co-owned with his brother, and evidence suggested that Keith had uncovered the scheme and was preparing to bring it into the open, which placed serious pressure on Paul as the situation escalated. Prosecutors also highlighted that with Keith and his immediate family gone, Paul stood to gain significant financial benefits, including access to a pension fund estimated to be worth nearly $3 million, which added a clear financial motive to the case. The matter was eventually brought before the Monmouth County Superior Court under Judge Mark Lemieux more than 7 years after the killings, which reflected the long and complex legal process that unfolded before trial could begin. After months of legal arguments and pretrial motions, the jury trial officially started on January 12, 2026, setting the stage for a closely watched courtroom battle. Then, on February 10, 2026, a major procedural
The actual physical phone that documents the screenshot, that physical phone and what's located there, do you agree with me that's an electrically a stored document within her phone? Do you agree?
From the moment she took it, sure.
And from the moment that you knew about it, correct? It's an electronically stored document, right?
I don't know if that's within the context of the discovery.
I'm asking you a question, yes or no. The answer is either it is, or in your opinion, or it's not. So
in my opinion, it is electronically stored in her phone. Yes, is it electronically stored? As far as do I have access to her phone? I didn't have access to her phone.
Well, actually you did, because you actually got a screenshot of it, according to you, the day before, so you did have access to not only to her phone, but the fact that you received a screenshot of it. Am I correct?
I would disagree, Judge. I'm on the phone with Katie. She's giving me information in live time. This is less than 24 hours before she's set to testify. And she informs me of something for the first time, and in live time says, and by the way, here's a screenshot of it. So this is less than 24 hours before she's testifying. It's not clear that this is, my understanding is if I'm not going to actually use the physical item, I didn't think it would be necessarily fair. I have to say, I had a fleeting moment to really think about it. But I didn't think it would be fair to surprise the state with this document and say I'm going to use this tomorrow, or I plan to use this tomorrow. So I relied on what she verbally told me to elicit the testimony. I think those are two distinguishable things.
I don't think they are. I don't think they are at all. I actually think that you had 24 hours, according to you, if you're actually assuming your information is correct, that you had a significant amount of time, that you had a screenshot of information that you knew you were going to elicit the next day, and that you did not turn it over. You didn't turn it over on Sunday. You didn't turn it over on Monday morning at 8 o'clock when we're all here a half hour before we started. You didn't turn it over at the first break at 9:30 or 10 o'clock. You didn't turn it over at the second break that we had at 11:30. You didn't turn it over at 12:30 during the break at that point in time. And you obviously didn't turn it over even after you asked the question about it. It wasn't until it comes up where I'm getting a brief at 10 o'clock at night, some 6 hours after the testimony, for the first time, the screenshot shows up and is now a part of this case. So, yeah, you did have time. You absolutely had time to turn it over, and it's not a fleeting moment. You knew with other text messages that you had, where you got somebody's phone records in the past, you actually turned those messages over. So you know that you actually have to turn over something that's in somebody's phone because it's electronically stored information. And the reality is that you decided not to do that. You intentionally and deliberately decided not to turn over discovery that you had in your possession before such time that that witness took the stand. So the state, at least at that moment, could have had the opportunity to say, hold on for a minute, we want to do some research on this before it comes out on the stand. TIER says one thing, it does. But TIER does not mention, and it does not deal with the fact, when something, it's not created by you, no one's asking you to create anything in this case, it already existed. This information was stored in her phone. It existed. You knew about it. You didn't turn it over. There's a difference. That's not what TIER is talking about. This, in this court's opinion, aligns more with State versus Knight. That is a 2024 decision, which I'll get into in my decision, which directly, in this court's opinion, is a situation where the defense has certain rights, and they absolutely, there is, I'm going to use the word imbalance, but only to the extent to preserve the defendant's constitutional rights. The defense does not have to turn over as much information that the state does. However, the discovery rules make it clear that electronically stored information needs to be turned over. You had it, and you didn't turn it over. So if your answer is anything other than, when I ask you if it's electronically stored information, if the answer is anything other than yes, it is, I got a problem with what you're saying. So I'm going to give you another opportunity as you're talking to the court. When you look at this information, is it or is it not electronically stored information?
Judge, frankly, I don't know. I don't think it's clear. Again, my interpretation of the discovery obligations are that if I am using something at trial, a physical, extrinsic document or piece of evidence, then I have to turn it over. And there were many things that were turned over months ahead of time because I had them months ahead of time. All I can say is I had this item the day before she was going to testify, and if I had not had the item, if it wasn't sent to me, and all I had was her verbal information, I would have just elicited the testimony. So I was relying on the verbal information, not the extrinsic information, to elicit the testimony. And that's all I can say.
That is...
If Your Honor disagrees, then Your Honor disagrees. That's all I can say.
I do disagree, because you know what you're doing? You're trying to walk a fine line and a tightrope on this situation, but you know that electronically stored information needs to be turned over. So that is why you're saying, I'm going to rely on the testimony that you know has electronically stored information to it. You know it. And you decided in a deliberate attempt to not turn it over, that you would just elicit it on the stand outside of turning over the physical screenshot in advance. So the state has some clue as to what was going on. The state didn't even have the opportunity to object. It happened so fast. So the reality is simply this. I hear you as it relates to this issue. I 1,000% disagree. This is not what the Supreme Court at any point in time contemplated when it considered TIER. This is not what it did. There's no way. And when I look at State versus Knight, it shows me that there are certain situations where the defense has to comply with the discovery rules. And this is not going to be trial by ambush, not in this courtroom or not in this state. So that's number one. Let's move on from the text message for a minute. I want to talk about the issue of these locations from February 2019. The electronic location that she looked at from 2019, is that stored in her phone as of today?
Not that I know of. She's just relaying what she saw back in February of 2019.
That's not what I'm asking you. I'm asking you whether Obviously, you're having a conversation with her as it relates to the other text message. And there, she's like, I have a screenshot. I can't sit here and not think that somebody who's preparing a witness in a case like this wouldn't ask a question. Do you have anything in your phone that says that the location comes back to Corey's house in February 2019? Are you saying that you never tried to see if that information's electronically stored in her phone?
That's exactly what I'm saying. I didn't ask that question because she just mentioned that when back in 2019 she looked at it and saw that it said that it was at Corey's house. And because I was under the impression that they obviously had the iPad at some point but never seized it or searched it the same way that they did to Sophia's phone. And just so that the record is clear, I also want to note the text message that she sent to Jennifer, the state did a cell phone extraction. They have her cell phone extraction. When I refreshed her recollection, I wasn't using...
I know you weren't. That's what makes it even worse. You decided to use an electronic document that you know was not 100% accurate, because the document that was 100% accurate, to refresh her recollection, would have been what you had in your possession, which was the screenshot, which included underneath the word red, which is what you supplied in your exhibit. So you had something, again, in your possession that you consciously decided not to turn over. And then when you're deciding to refresh somebody's recollection, you decided to use a document that, okay, this is in discovery, so I'll use this, but then I'll ask questions and get a verbal response as to the other.
Judge Lemieux made his frustration clear as he addressed Ms. Mastalone over the failure to disclose critical electronically stored evidence, and he stressed that such omissions directly challenge the fairness of the trial process. He pointed to New Jersey Court Rule 313.3, which requires the defense to follow strict reciprocal discovery duties, including sharing all tangible materials, documents, and electronic records that they plan to use during trial. And he reinforced that this rule is not optional, but essential to maintaining order in court. The judge explained that this requirement exists to protect the integrity of the legal process by making sure every piece of evidence is carefully reviewed and verified before it ever reaches the jury. And this step ensures both sides are prepared to respond properly. The issue became more serious when it was revealed that the defense had allowed their witness, Ms. Katie Cano, to prepare testimony based on data stored on an iPad, even though that data had never been provided to the prosecution at any point before trial, which raised immediate concerns about fairness. Ms. Mastalone argued that the witness would only describe the information verbally during testimony and would not formally introduce the digital material itself, but the court did not accept this explanation. Judge Lemieux firmly rejected that position and referenced the legal precedent of State v. Knight, which highlights the ongoing duty of legal counsel to disclose digital records, metadata, and electronic communications throughout the case. He made it clear that simply describing what appears on a screen is not an acceptable replacement for submitting the actual electronic record, and such an approach does not meet legal standards. The judge further clarified that whenever a witness relies on electronically stored data, the original digital source must be provided to the opposing side, so they have a fair chance to review the material, verify its authenticity, and prepare effective cross-examination. And he warned that failing to do so risks turning the trial into what is known as a trial by ambush, which the court will not allow under any circumstance.
Recalls the witness mentioning, so I guess this is during a conversation that you had with her, that she confronted Corey about it, either text or phone call. Do those exist?
I don't know, Judge. I'm being in candor to everyone. I'm just relaying the context of the conversation and what was told to me. That's all. The court is clearly being accusatory toward the defense. The court is using words such as conscientious or conscious and deliberate and intentional.
I'm using it because it's true. I'm using it because it's true, Ms. Mastalone. So don't say that I'm using these words for any other reason, because you did this. I didn't do it. I've given you the opportunity to ask questions and do whatever you need. And the reality is, you can roll your eyes for the record, as you just did, but the reality is simply this. You were given the opportunity under these circumstances to turn over electronically stored information, and you didn't do it.
If that's the court's finding, then that's the court's finding, Judge. It doesn't seem to me that there's anything that I can say to further my position that that this was not a discovery violation, nor was it an intentional discovery violation. So if the court finds otherwise, and the court clearly has, then there's nothing further that I can say. The defense has made every effort to try to be transparent in light of the fact that of the unique nature of this case. I've never had a case where I've had to go to sidebar so many times to make sure that it's okay to ask certain questions, as I did before Katie Canero's testimony. This was not something that I anticipated would be an issue. I elicited something that she verbally told me, and that was it. There was a 25-page ex parte letter that pertains to Corey Canero. The court made rulings. I advised the witness accordingly of what she was and was not permitted to say. This was something that came up at the last minute that didn't seem to me to have the message about Jennifer's phone has nothing to do with Corey Canero.
Didn't I rule as it relates to any post behavior by Corey and/or his wife or ex-wife that I was not going to allow some of this conduct to be brought out? Didn't I say that in my January 27th?
Absolutely, and this wasn't.
Okay, so hold on.
It was just failure to investigate and seize and search the iPad.
No, that's actually not, because the first thing that you say
is that people were in the home.
I'm sorry, I think I was talking. The first thing that you say deals with the fact that they are in the home. They are in the home taking stuff out. It demonstrates that Corey was taking items from the house after the homicide, which lends to further credence to the defense's earlier point.
Yes, exactly.
The reality is this. It goes to his behavior. It doesn't go to the fact of something that happens in 2020. A contamination of the scene in 2020. It's not like we have evidence here of Corey's DNA in the kitchen so that we have some contamination issue. What this evidence is being used for is to show that Corey is actually in the house just taking items out, and it goes to his behavior. That's what I find. It goes to his behavior, which is exactly what, in my January 27th order of a 42-page opinion, which I said specifically that